So you have your case and you file the lawsuit, and now you want to sit down and draft and ask for discovery. And rather than do that, you start asking friends, hey, what kind of discovery do you use? And what kind of interrogatories do you use? And you just start asking for people. You look at a chart in a medical malpractice case and you start asking for everybody who ever cared for your patient. Is that really a good idea? Is that good discovery? Is that what you really want to do? My name is Saul Gruber, and I'm at Gruber Trial Consulting. And we help law firms all over the country take their cases and help prepare them by doing something called a discovery plan. Now, a discovery plan is something I don't see a lot of lawyers doing. Why? Because we all know how smart we are, right? We know what we're doing. I don't need a discovery plan until you're up against the end of discovery date and you haven't gotten any of the things that you need. That's why we recommend and we help our clients actually prepare a discovery plan. So what's the first thing you do when you're going to prepare the discovery plan? You're going to pull the jury charges in your jurisdiction for the type of case it is and the damages that you're entitled to. You want to have that before you actually prepare your discovery plan. Why? Because you want to know what you have to prove and how you have to prove it, and that's how you're going to go about handling the case. And what I mean by that is if it's a malpractice case, you need to know what the proofs are in a medical malpractice case. Then you begin to say, how am I going to make sure I have evidence to satisfy those proofs? Well, the first thing we do is draft some very specific and minimal interrogatories. You've seen the video about interrogatories and you understand my position. My position is they are nothing more than questions to help a defense lawyer build their file and to come up with as many objections as they can. We don't really care about it. What documents do you think you really need? That's what you ask for in your interrogatories. That's what you may ask for in your first request for production of documents. In our nursing home cases, we advise all of our clients not even to bother with an initial request for production of documents. What we do is conduct a local 30B6 records deposition of all the records that can possibly be held by the nursing home and its corporate owner. Then all you do is ask the person that question, the deponent, and there you will get your predicate for all the records you need to obtain. But that's for a different video. So what do you want to do? You've got to do things in order, right? So the first thing you're going to do is have your bare minimum interrogatories that you have to have right away, things that are very difficult to object to. Then you have either a 30B6 records dep or a request for production of documents, of the documents you need, knowing that there may be some objections to that you'll deal with at a later time. Then you get that back and determine, are there any initial requests for admissions that you can do based on what information you just got to help streamline the case, or more importantly, to help set up later discovery. I like to see discovery in at least two tiers. The easy stuff first, build a little bit of a predicate, then ask for the more complicated things. So if it's a medical malpractice case, they may not want to give you their policies or incident reports right away, although you've requested them. Well, you do one or two depositions that it doesn't really matter if you have them. Then you prepare a predicate in the question so that using the witness's own words, you can then file your motion to compel the discovery you need. And it's not you arguing it, and it's not the defense attorney arguing it. It's the witness telling you why you need it. And what we're doing is putting deadlines to it with dates, your first set of interrogatories. And maybe there's a second set of interrogatories. Obviously, it depends on the type of jurisdiction you practice, if you're limited in any way. Don't take 15 depositions right away. Take your first set of depositions, see what you proved, and then see what else you need to prove your case, or maybe to advance it to the next case. And you continue to do that until your discovery end date. And if you do that, you will have everything you need. Maybe a little hard, you may have to fight, but you'll get it all, and you'll get it all in a reasonable way, and the way that proves your case. Again, I'm Saul Gruber from Gruber Trial Consulting. If you like this trial tip, please hit subscribe on the bottom of the video, and you can get alerted to all of our tips, including our Nursing Home Minute and our Art of Persuasion. Also, look for our podcast anywhere you get podcasts. The jury thinks what? On the Lawyer Minds ecosystem. And if you need anything, always call us. We're here to help.